Thank you. I know you're still salivating about and that very insightful address by the Honorable Minister of Finance from Nigeria. But I want to welcome you to our plenary roundtable entitled Anti-Corruption Assessment and Strategies in the Region. And for this session, we are indeed extremely privileged and honored, I might add, to have in our midst and to share their perspective with us a very distinguished panel consisting of our own Premier of the Cayman Islands, the Honorable Alden McLaughlin, MBE, Mr. Grenville Williams, who is representing the Honorable Prime Minister of St. Vincent and the Grenadines, and representing the Honorable Premier of Bermuda is Ms. Cheryl Lister, who is Chair of the Bermuda National Anti-Money Laundering Committee. Ladies and gentlemen, we are aware of how busy our Premier is, and therefore we consider ourselves very fortunate that he has decided to spare some time to be with us and to help to distill this very topical issue of integrity in public life. Unfortunately, Prime Minister Gonzalez could not join us because of some last-minute development which requires him to remain on the ground in St. Vincent, but he has sent his apology and has also sent Mr. Grenville Williams, who will ably represent him. In the same breath, ladies and gentlemen, we are extremely grateful to Ms. Cheryl Lister for agreeing to attend and represent the Honorable Premier of Bermuda. Please join me in giving our panelists a warm welcome. Ladies and gentlemen, we are aware that whatever will be happening over the next 3 days, someone has to be picking up the tab. In that regard, we are ever so grateful to have our major conference sponsor, EY, formerly Ernst & Young, playing that role. And ever present among us is no other than the regional managing partner, Mr. Don Scott, a very extremely busy man himself. And so we are honored to have him here this morning. Please also give him a round of applause. I am going to now ask Mr. Scott to say a few words by way of remarks. Thank you.
Good morning, ladies and gentlemen. Thank you, Honorable Attorney General, for that kind introduction. I want to thank the University College of the Cayman Islands for organizing this very important event. The issue of corruption is critical to our economies, so great credit goes to UCCI and to all of you for this event and playing a role in its success. Today, I am privileged to introduce our EY-sponsored plenary, Anti-Corruption Assessment and Strategies in the Region. Corruption is not simply a matter of financial malfeasance. It has a significant impact on the ethics, values, and moralities of our regions. It affects the way the world views the region. And indeed, we heard earlier from our keynote speaker, despite the fact, and I spend much of my time serving clients in the financial services industry, and I will tell you the vast majority of the work that is done in the business that is done in the Cayman Islands is indeed legitimate. Having said that, we do recognize that we do make headlines for that business which does support illicit activity, and that far outweighs in the international press the good work we do. So what it points us to is that we must do more, and we must not tolerate any of that business in the Cayman Islands. So it either views us as a stable place to conduct business or as a region with undue risk and a playing field that is not level. Fortunately, the scourge of corruption has been commanding more attention in recent years, resulting in high-level examinations of the issues, recommendations, and game-changing awareness initiatives. Panama City recently hosted the 5th session of the Conference of States Parties to the UN Convention Against Corruption. Last December in Washington, D.C., the World Bank sponsored an executive panel entitled Speak Up Against Corruption with Paul Volcker, former chairman of the U.S. Federal Reserve, and the anti-corruption mechanism of the Organization of American States, the OAS, will hold on-site visits in April in the Caribbean region. An anti-corruption focus is commanding considerable attention from government leaders, industry regulators, and business executives today. And we are having an impact. In 2012, a United Nations report entitled Anti-Corruption Programs in Latin America and the Caribbean speaks to our progress. It reads, collaboration between public and private entities, governmental and civil societies, governments, donors, and international agencies is already a reality of anti-corruption work in the region. This collaboration is truly a hopeful sign, but we all must do more. The private sector and government must work more closely. In the face of new stringent legal requirements and regulatory demands, business need to embed compliance and risk management across their organizations. So how can the private sector, in conjunction with government organizations, help in this fight? We at EY have defined steps that businesses can take to reduce their corruption risk. Some of these include companies must demand anti-corruption culture by performing their own due diligence. The Chief Compliance Officer needs to be supportive of good conduct and a savvy investigator of corruption. Companies must perform effective data analytics and management to find clues that suggest possible misconduct. Senior management must be informed and empowered to respond swiftly to corruption with employees and business partners. Every corruption investigation is unique, so the circumstances will dictate how specific procedures should be performed. With small businesses, some of these roles need to be carried out by owners and management, since sophisticated infrastructure are not likely to yet be in place. However, know that it is the responsibility of every business, regardless of your size, to fight corruption. This is a very important topic to me personally, because my colleagues and I at EY have recently committed ourselves to a new vision: building a better working world. Our mission aligns perfectly with today's event goals: increasing trust and confidence in both the public and private sectors here in the region, so that working together, we can drive more business and sustainable growth to our economies. By strengthening trust and confidence in our region's organization, we can continue to attract the investors and the visitors that are so critical to our future development. And with that, I will turn it back over to the Honorable Sam Bulgen, Plenary Chair. Thank you.
Thank you very much, Mr. Scott, for that very timely reminder. Ladies and gentlemen, as you heard, we do not need empirical data to tell us about how corrosive corruption is. It is corrosive and it is pervasive. And I'm here speaking about corruption in all its manifestations, and whether in the public sector or in the private sector. It has continued to have a deleterious effect on national economies. The World Bank has estimated that up to $40 billion per year is pilfered from developing countries by corrupt officials. And you heard this morning examples of staggering amount being siphoned off by public officials and head of states. There is an annual scorecard, if you will, that now used to measure a country's public sector, how perceived a country's public sector is perceived to be, how corrupt it is, sorry. And that is Transparency International, the Corruption Perception Index, which score countries on how corrupt their public sector is seen. And a country's score indicates the perceived level of public sector corruption on a scale of 0 to 100, where 0 means that the country is perceived as highly corrupt. And of course, the closer the country is to 100, the cleaner it is perceived to be. Our region, the Caribbean region, which is the subject of this segment, has enjoyed mixed ratings in the most recent publication. And it is therefore timely that the UCCI is staging this conference, and it is significant that we have eminent panelists from our region, if Bermuda don't mind be so classified as part of the region, to share their assessment and strategies, indeed their perspective, their insight, if you will, as it relates to the fight against corruption regionally and more globally. All our panelists, as well as Mr. Scott, you heard here, have been very vocal and indeed very passionate in advocating the need for probity and integrity in public life. Their presence here today is therefore a further affirmation of their ongoing quest to try and impart those core values in their respective countries and indeed in the region. Indeed, ladies and gentlemen, our Premier recently spoke on the issue of corruption when he addressed the Chatham House Conference and during his appearance on the BBC Hard Talk earlier this year. He reminded us then that for the fight against corruption to stand any chance of succeeding, it has to be global. For our part, we in the Cayman Islands continue to take steps to ensure that we are governed by international standards. Indeed, our Parliament enacted anti-corruption legislation in 2008, came into effect in 2010. We have an anti-corruption commission. The UK Bribery Act has some application to the Cayman Islands. The OECD Bribery Convention has been extended to the Cayman Islands. And we are in the process of having the United Nations Convention Against Corruption extended to us to sort of underpin the domestic legislation that we already have in place. We are also have been rated largely compliant with the 40 revised FATF recommendations, and we have also been rated as largely compliant with the OECD framework, or standards rather, as it relates to the exchange of information on tax matters. However, we will admit that it is a work in progress and that we do have challenges, and we continue to do what is necessary to ensure that our jurisdiction is well regulated. I must observe, however, that we cannot legislate morality. We cannot legislate integrity. You cannot legislate for integrity in public life. It takes values, it takes attitudes. It requires having the right person in public offices and in the private sector who will neither get involved with or condone or facilitate the scourge of corruption, and only then will we succeed. Ladies and gentlemen, we have with us this morning our Honorable Premier. He has been an elected member of the Legislative Assembly since 2000, continuously, for the electoral district of Georgetown. He became leader of his Progressive Party in 2011 And in 2013, he was sworn in as Premier of the Cayman Islands. He is an attorney of 25 years call. He has been honored for his work on the creation of a modern constitution for the Cayman Islands with an MBE by Her Majesty the Queen. He is very passionate about these issues, and I'm sure you're not here to hear from me, you're here to hear from him, and so I will get out of the way and allow him to bring remarks to you. Thank you very much, and welcome our Premier, please. Thank you.
Thank you, Mr. Attorney General. Good morning, everyone. I'm going to dispense with the usual protocol and just say, distinguished ladies and gentlemen, I just need to correct the Honorable Attorney General on one point. He described me as an attorney. I am actually a recovering attorney in the way that you have recovering alcoholics. I haven't really practiced for some years now. I wish to thank President Roy Borden and the leadership of the University College for hosting this most important conference on a corruption-free Caribbean. It is the second opportunity I have been afforded this year to speak to a distinguished group of people about corruption, be it real or perceived. I was fortunate to have been invited to give one of two keynote addresses at the Chatham House Conference Combating Global Corruption in London early last month. It is right, I believe, that we have these discussions on a global, regional, and even local scale, which is why conferences such as these are important. And I thank the university and the staff for once again taking on the challenge. There is much to be done globally and even locally to educate everyone about corruption and about what is necessary to eradicate it. While we will never completely wipe out corruption, we must be ever vigilant against it on all levels, from local district councils to looming central governments, judiciaries, the public service, the private sector, and more. I believe that the message being sent through these types of conferences, summits, and talks will shine some light on corrupt practices and help bring them to an end. Today I've been asked to speak about the ethical and anti-corruption framework of the Cayman Islands and lessons that other countries in the Caribbean can learn from us. I will admit that while I do not believe that the level of corruption seen in other parts of the world exists in the Cayman Islands, I have no doubt whatsoever that corruption is here. We are not perfect by any means. And because we are not perfect, I appreciate that while there are things we can teach others, there are also things that we can learn. And I look forward to being enlightened over the course of these few days on what some of the experiences and the successes of our neighbors are. I guess the short answer to the question of how to end corruption would be to tell the truth and avoid secrecy in the affairs of government. By taking the secrecy out of the way government works and the decisions it makes, the scope for corrupt practices is greatly diminished. I firmly take to heart the words of American politician and statesman Adlai Ewing Stevenson II when he said, "Government is more than the sum of all the interests. It is the paramount interest, the public interest. It must be the efficient, effective agent of a responsible citizenry, not the shelter of the incompetent and the corrupt." The Cayman Islands has gained what I regard as an unfair reputation as a place where all sorts of crooks can stash their loot. The facts are that in terms of due diligence and anti-money laundering legislation, we are a world leader. As I told the delegates at Chatham House, for some 15 years, the Cayman Islands has been placed under an unfair microscope by the range of supranational bodies charged with setting global standards with respect to anti-corruption, tax information exchange, and anti-money laundering measures, being poked and prodded, but we welcome the scrutiny because each review has made our legislative and regulatory regimes that much more robust. We are always found to be in compliance, and in some areas more so than developed countries. Since taking office in May of last year, our government has striven to restore confidence in government by subscribing to and practicing the principles of good governance. Through good governance in the public sector, we are assuring the people of the Cayman Islands, and indeed the world, that we are effectively using resources, improving on delivery of services, and strengthening government's accountability. In the Cayman Islands, the framework for good governance is found in our Constitution, in the Public Service Management Law, and in the Public Management and Finance Law, which was recently amended to include what is called the Framework for Fiscal Responsibility. Through this sound framework, we achieve an extremely high standard of transparency and accountability for and in the country. Just this past February, we charged the Financial Services Councillor Roy McTaggart to set up a working group to develop a legal framework for the automatic exchange of tax information. This group is made up from the public and private sectors with an aim to provide recommendations for draft primary legislation that is slated to be considered by the Legislative Assembly in May this year. The group will also work on draft regulations and guidance notes for Cayman's financial services industry because its remit goes beyond FATCA and encompasses future international automatic exchange of information agreements. Part of our efforts to fight corruption, both at home and globally, are through the signing of various tax information exchange agreements. We are members of the steering and peer review groups of the Global Forum on Transparency and Exchange of Information for Tax Purposes. We are also a member of the Global Forum's newly formed AEOI group, which is examining how to effectively answer the G20's call for the forum to monitor the implementation of automatic exchange of information as the new global standard. I say all of that to say this: no government can end corruption in a vacuum. Much of combating corruption comes through the adoption of an aggressive legislative agenda for both government and business. A key piece of legislation that was passed during my party's previous administration in 2008 is the anti-corruption law, which the Honorable Attorney General referred to. This is supported by the Anti-Corruption Committee. We encourage anyone who does business with public bodies in the Cayman Islands to acquaint themselves with this law because it applies also to them, not just public officials. The law covers public offices from justices of the peace to the Legislative Assembly and Cabinet. It also covers persons serving on all statutory boards and authorities, tribunals, commissions of inquiry, even jurors. It covers a range of offenses from bribery of public officers and members of the Legislative Assembly, frauds on government, contractors subscribing to election funds, breach of trust by public officials and members of the Legislative Assembly, abuse of office, bribing foreign public officials, and conflicts of interest, among others. And we have an anti-corruption commission that is charged with administering the law. The Anti-Corruption Commission has a broad range of powers to investigate reports on corruption, liaise with overseas anti-corruption authorities, and obtain court orders to freeze the assets of those suspected of committing corruption offenses. The ACC is considered a vital body for investigating reports of corruption to help promote the accountability and public confidence in the Cayman Islands. We do recognize that we cannot fight the scourge of corruption alone, and thus work closely with countries and bodies regionally and further afield. But all of our laws aren't just for compliance globally. We know that to end corruption in the Caribbean, we have to begin at home. The Gospel of St. Matthew, chapter 7, verse 5, says, "First take the plank out of your own eye, and then you will see clearly to remove the speck from your brother's." On 31st of January this year, we pushed through the standards in public life law that requires anyone in public life, from lawmakers to board members, to make a declaration to the Commission for Standards on Public Life of their income, assets, and liabilities. Those who fail to do so could face hefty fines and possible imprisonment. This is a very serious piece of legislation, but it is necessary because we must ensure that conflicts of interest do not influence or color the decisions that are made by those in authority. We believe that while the law has far-reaching consequences, it will be nothing but positive for the reputation of these islands. Recognizing that having a solid, transparent procurement process is a key part of combating corruption, the process as outlined in the framework of fiscal responsibility, which I referred to earlier, and which has been enshrined in our public management and finance law, seeks to ensure that best-in-class procedures are followed to ensure correct outcomes in the procurement process. I speak mainly now of our cruise berthing, airports, and landfill projects which are under consideration by this administration. To avoid corruption and maintain transparency and good governance, the rules now require that we must first create a strategic outline case which will provide an overview of the issue and identify and broadly assess the various options for the budget of each of these projects. The strategic outline case will form the basis for what is called an outline business case, which will provide further evaluation of options and result in a better definition of the project for procurement. To further ensure transparency, there will be an environmental impact assessment for each project and consultation with stakeholders. While we recognize the need to end corruption in the day-to-day workings of government, we have to acknowledge that corruption exists in other areas throughout the region and the world, especially when it comes to elections, and especially in the Caribbean. While we have an election law that governs how the process is supposed to work, and that the result is fair and free of corruption, last year we welcomed observers from the Commonwealth Parliamentary Association, despite objections from some of our candidates. In the end, the observers wrote a report and concluded, and I quote, "In our view, the 2013 general elections in the Cayman Islands met the international standards for democratic, genuine, and transparent elections, and the results truly reflect the will of the people," unquote. Indeed, when asked to evaluate the Cayman Islands on a scale of 1 to 10, with 10 being the highest, the Cayman Islands received a 9 when it came to properly and fairly conducting public voting. But even before the election observers arrived on our shores, our elections office was working diligently to ensure that voting was free of corruption. They terminated 2 election workers for not complying with their oath of office, and even the police commissioner got in on the Anti-Corruption Act when he advised political camps and voters to file complaints of voter bribery, which he said would be investigated and prosecuted. If we are honest with ourselves, and we have to be if we want to develop a sustainable, ethical, and anti-corruption framework throughout the region, we have to admit that election irregularities have occurred and continue to do so in the Caribbean. Time and time again, we hear stories of election fraud, of vote buying, whether it is cash in an envelope, a bottle of rum, a new washer or refrigerator, intimidation, threats, and even acts of violence in elections the world over. We can't keep ignoring election fraud if we are truly to stamp out corruption. Those who are guilty Both the candidate or party and the voter must own up to it, admit it is wrong, and help move their country, its people, and the region forward. I repeat, we cannot stop corruption locally, regionally, or globally unless we are all on the same page. There will be those, like the candidates who don't want elections to be observed, who get into office using illegal means, trying to thwart anti-corruption initiatives, but it is they who must be brushed aside so that good governance and transparency can thrive in all branches of government. Working together is a lesson many in the Cayman Islands government learned with the advent of Cayman's Freedom of Information law in 2007, which has now been in effect for 5 years. Getting that piece of legislation out the gate was no mean feat. At first, many of those charged with dealing with FOI requests were unsure of what they could and could not produce. But eventually, through training and working together, I believe we are getting there. Since the inception of Freedom of Information in the Cayman Islands, more than 3,000 open record requests have been filed under the law, which lets anyone, anywhere in the world, request public information from Cayman's more than 90 government agencies. The foresight of the then PPM administration, now the Progressives, and of which I am the leader, in pushing through the FOI law in the early part of this century, went a long way to combating and even revealing corruption in this country. FOI provides an independent or unbiased source of information regarding real or perceived corruption. 2, we have a robust Auditor General's operation with an internal audit unit that has been instrumental in getting information to the public. And that's what it's really all about, getting pertinent information to the public about how government works and is functioning to put an end to real and perceived corruption. Governments, their authorities and agencies must be forthcoming with information that is requested. Better yet, government should be disseminating prudent information before media and the public request it. There is much information that should already be available to the public that the public shouldn't actually have to seek out by virtue of a Freedom of Information request. So to return to my topic, the ethical and anti-corruption framework of the Cayman Islands and lessons that other countries in the Caribbean can learn from us. I hope I have made it clear that we as individual states and countries will not stop corruption in our region on our own. We all have to work together to make sure the truth about our governments and who we work with is out in the open, that our actions are transparent. It takes a willingness to comply with and working together while ensuring that the floors of our own houses are swept clean of corruption. I believe over the course of these 2 days, the conversations and discussions that will take place will be a helpful start to making the improvements that are needed across the region. The more we understand of the problems before us, the better equipped we can be to take decisive and effective action. I am pleased this morning to be joined as part of the panel discussion by Ms. Cheryl Lister, who is the chair of the National Anti-Money Laundering Committee in Bermuda, and by Mr. Grenville Williams, the Director of Financial Intelligence Unit in St. Vincent and the Grenadines. I am a little disappointed that I don't have the pleasure of my friends, the Premier of Bermuda, Craig Cannonier, and the Prime Minister of St. Vincent and Grenadines, Dr. Ralph Gonzalez. Particularly going to miss Dr. Gonzalez because I knew if he was here, I wouldn't have to answer many of the questions. Anyone who knows Dr. Gonzalez. Thank you all for your attention.
Thank you, Honorable Premier, for giving us the Cayman Islands perspective. Before I introduce our next speaker, Mr. Grenville Williams, let me just say one other thing about the perception and the use of statistics and how it can be interpreted. In the context of the Cayman Islands, one of the questions that is often asked is, well, you say you met international standards, but how many money laundering prosecutions have you had in the last 5 years or 6 years? Well, we need to understand the nature of the business in the Cayman Islands. It might be frowned on that we have had very limited amount of criminal prosecutions for money laundering. But if you understand the business of Cayman Islands, which is a transient society, invariably what happens is that you have an accused person who lives in the United States or one of these other foreign countries. You have the victims who live in the United States or one of these foreign countries. And the only thing you have in the Cayman Islands is documents evidencing that a bank account is open here or that a company was registered here. One of the most effective ways of fighting transnational organized crime, which is what money laundering is all about, is to have in place, among other things, an effective mutual legal assistance arrangement, an effective international cooperation regime. Cayman Islands boast maybe one of the best. We have a mutual legal assistance agreement with the United States, for example, where we have provided in excess of 400 requests, partnered with over 400 requests in the last couple of years. So what will happen is that because the accused person and the victims invariably live in the United States, and we use the US as an example, it's far more convenient for the US to come to the Cayman Islands and say, can you provide us with copies of the documents for the bank account, copies of the documents evidencing the opening of a registration of a company or incorporation of a company. Everybody's in the United States. The prosecution is done in the United States. And at the end of it all, if there are no victims to be restituted, if there are no restitution issue, we have what is called an asset sharing agreement. And that is the arrangement that we have with the United States, we have it with Canada, we have it with the UK, and we have it with all of these countries. So don't be fooled by the fact that we might want to have a limited amount of money laundering prosecutions here. We are playing our part as it relates to effective exchange of information to assist with these prosecutions. And it is the same way we deal with our tax information exchange matters. We don't have tax crime in the Cayman Islands, so we wouldn't be prosecuting people here for tax offenses. But we have one of the most robust arrangements for tax information exchange agreements, where we send these informations to people abroad for them to conduct their prosecutions in a domestic way. So that, I hope, will help to clarify this perception that very few money laundering prosecutions mean that there's an effective lack of effectiveness as it relates to our regime here. Ladies and gentlemen, we have the pleasure of having with us this morning Mr. Grenville T. Williams, Director of Financial Intelligence Unit from St. Vincent and the Grenadines, who is here representing the Honorable Ralph Gonsalves, Prime Minister. Mr. Williams is an attorney at law, graduated from the University of the West Indies Cayman campus. He is also he has his legal education certificate, and is a practicing attorney, and has some 6 years experience working with the Financial Intelligence Unit in St. Vincent and the Grenadines. He has served in various departments of the Financial Intelligence Unit, and of course he's now the director. And in 2007, he was instrumental in obtaining the first successful money laundering prosecutions and forfeiture application in St. Vincent and the Grenadines. We are happy to have you, sir, and we ask you to bring the perspective from St. Vincent and the Grenadines. Thank you.
Thank you.
Members of the head table, distinguished guests, ladies and gentlemen, good morning. I am here this morning to make a presentation on behalf of Dr. the Honorable Ralph E. Gonsalves, Prime Minister of St. Vincent and the Grenadines, who could not be here with you this morning as a result of matters of state that required his personal attention in St. Vincent and the Grenadines. I bring you greetings, I bring you commendations, particularly to the university, the sponsors, and the government and people of the Cayman Islands for the importance that they have placed on this issue, one that they see relevant to be discussed and assessed by the various agencies, the various schools, and other organizations present here today. And as I said, I speak on behalf of the Honorable Prime Minister and his presentation as such. I am honored to have been invited to address this high-level international conference, which is being held under the broad theme, Toward a Corruption-Free Caribbean, Ethics, Values, Trust, and Morality. Originally, I was asked to speak on the subject, the ethical and anti-corruption framework of St. Vincent and the Grenadines, Lessons for the Caribbean. This request, however, has recently metamorphosed into a presentation on a panel on the subject, Anti-Corruption Assessment and Strategies in the Region. I assume that I am required, in this regard, to draw on the experiences of St. Vincent and the Grenadines. I begin with a few declarations in relation to St. Vincent and the Grenadines. First, the government of St. Vincent and the Grenadines is deeply committed to the theory and practice of good governance, including the practical quest for a corruption-free regime of governance. Broadly, there are institutional, political, and community support for an internationally accepted good governance arrangement in my country, despite weaknesses grounded in institutional and resource limitations. Secondly, the quality institutional arrangements for good governance manifest themselves, among other things, in a functioning liberal democracy with checks and balances, transparent and accountable government, an independent and highly respected judiciary, an independent, constitutionally protected, and reasonably well-staffed Office of the Director of Public Prosecutions, an independent, functioning, and transparent process of government procurement for goods and services, an independent and constitutionally protected Office of the Director of Audit, a largely professional police force, Coast Guard, Customs, and Immigration, devoid of political or other undue external interference in their investigative or managerial work, an independent, well-staffed financial services authority, the regulatory agency for all non-bank financial institutions, including all offshore financial entities, an independent, well-run regional central bank, the Eastern Caribbean Central Bank, which regulates all domestic commercial banks, and an independent, professionally staffed public service and police service commissions. Thirdly, a highly acclaimed financial intelligence unit, which, since its establishment in early 2002, has become arguably the best such agency in the Eastern Caribbean. The FIU oversees the implementation of excellent statute law relating to the proceeds of crime and money laundering. Fourthly, the statute law contains a bundle of provisions addressing criminal offenses relating to official corruption. However, the legal regime has a gap in that there is an absence of legislation regarding declaration of assets and liabilities and illicit enrichment by parliamentarians and other high office holders. Fifthly, St. Vincent and the Grenadines was recently ranked in ascending order at a commendable number 33 out of 177 countries assessed by Transparency International in terms of its Perception of Corruption Index. It is one of the better performances globally. St. Vincent and the Grenadines scored 62 out of possible 100 marks. Close to two-thirds of countries worldwide recorded scores of below 50%, including our Caribbean neighbors such as Jamaica, Guyana, and Trinidad and Tobago. Sixthly, the comparative evidence suggests that truly open, democratic systems of government with strong, supportive political and civil cultures tend to have far less corruption than others which lack such democratic government, civic, cultural nexus. Indeed, countries which specifically targeted legislative and institutional arrangement against corruption hardly achieve their anti-corruption purposes if the underpinning cultural milieu is not supportive. In other words, those countries which objectively solely need integrity legislation and accompanying targeted institutions are countries in which such laws and institutions are unlikely to have more than a very limited effect. For example, Barbados, which lacks such an integrity law and institutions, score much better in the anti-corruption league tables than, say, Jamaica and Trinidad and Tobago, which have stringent integrity laws and specific anti-corruption institutions. We'll now look briefly at the summary of experience of St. Vincent and the Grenadines between the period 2001 and 2014. My government was first elected to office on March 28, 2001. It was re-elected in 2005 and 2010 general elections. On arrival in office, we met the following conditions of relevance, among other things. 1, a blacklist imposed by the Financial Action Task Force, the FATF, on account of the country's highly inadequate regime for addressing money laundering and the proceeds of crime. 2, the presence of an international financial services sector, including 40 offshore banks, which was most inadequately regulated. 3, the loss of corresponding banking arrangement in the United States of America for the state-owned National Commercial Bank, a significant domestic commercial bank. 4, the denial by the British government of debt relief for St. Vincent and the Grenadines under the Commonwealth Debt Initiative for 4 reasons, namely, the failure of the NDP government, the predecessor to my government, to practice good governance. The said government's failure to put an adequate regime in place to regulate the offshore finance sector and money laundering. The widespread belief of the prevalence of official corruption, and the said government's failure to tackle poverty effectively or in a focused manner. Swiftly, my government commenced the establishment of a sounder regulatory regime to address the international financial services sector and money laundering. Initiated a reform process in the National Commercial Bank, which led to a restoration of corresponding banking arrangement in the United States of America. And within 5 months, secured debt relief from the British government under the CDI on account of our proactive policies in cleaning up the offshore banking sector, curbing official corruption, addressing money laundering effectively, and focusing strategically on poverty reduction. Within 8 months, a highly regarded piece of legislation was passed to tackle robustly money laundering and the proceeds of crime. And within 5 months thereafter, a financial intelligence unit was set up for the first time ever. In less than 1 year after its establishment, the FIU of St. Vincent and the Grenadines was invited to join the prestigious Egmont Group, an umbrella entity internationally of quality FIUs. About the same time, the FIU removed St. Vincent and the Grenadines from its blacklist. It is instructive to note that most of the offshore banks were unable to meet the new, higher regulatory standards. In 1 year, the number of offshore banks fell from 44 to 9, and shortly thereafter to 6. Concurrently, my government embarked upon a process of enhancing good governance arrangement and practices designed to uplift open government, transparency, participatory government, and accountable governance. All of these measures contributed to making official corruption less likely to be practiced and more likely to be detected and exposed, and where credible, admissible evidence exists, for the perpetrators to be disciplined and or prosecuted. Among the legislative amendments and enactments and further institutional strengthening arising therefrom, touching on concerning the government's financial administration, audit and accountability, and financial transparency, the government put into law several statutes, namely the Finance Administration Act, the Money Services Business Act, the Audit Act, the Proceeds of Crime and Money Laundering Prevention Act, the Financial Intelligence Unit Act, and the Financial Services Authority Act. These legislative measures rest upon a bedrock of a sound law and order platform, which includes legislative initiatives and reforms in the criminal law, criminal procedure and evidence, extradition, protection of witnesses, and the use of modern information technology for the recording and admissibility of evidence in criminal trials. There has been a rollback of evidential and procedural advantages to defendants in criminal cases without in any way undermining the individual's fundamental rights and freedoms, including a right to a fair trial within a reasonable time. In the area of international financial services, there is a comprehensive menu of modern, sanitized laws which are well policed in accordance with acceptable international standards. These were enacted by my administration. As it relates to official corruption, in the Criminal Code, Chapter 171 of the Laws of St. Vincent and the Grenadines, the offense of official corruption is defined thus. Section 85. Any person who, A, being employed in the public service and being charged with the performance of any duty by virtue of such employment, corruptly solicits, receives or obtains, or agrees or attempts to receive or obtain any property or benefit of any kind for himself or any person on account of anything already done or omitted to be done, or to be afterwards done or omitted to be done by him in the discharge of the duties of his office, or B, corruptly gives, confers or procures, or promises or offers to give or confer, or to procure or attempt to procure, to or upon for any person employed in the public service, or to or upon for any other person, any property or benefit of any kind, on account of such act or omission on the part of the person so employed, is guilty of an offense and liable to imprisonment for 3 years. Criminal offenses exist for the following, among other things: extortion by public officers receiving property to show favor, false claims by officials, and abuse of office. No person, to the best of my knowledge, has ever been prosecuted for any of these offenses since independence in 1979. However, public officials and one former government minister have been prosecuted and in several cases found guilty of theft, various offenses, including one or other of the many offenses against property involving dishonesty, bribery, fraud, and misbehavior in public office. The normal functioning of the public service, the police, the Office of the Director of Public Prosecutions, and the law courts cause the offenders to be brought to justice. One area in which there is universally a potential for corruption is in the procurement process for goods and services purchased by government. There is in St. Vincent and the Grenadines an independent functioning General Tenders Board, which is chaired by the Director General of Finance and Planning and consists of other public officers and persons drawn from civil society appointed by cabinet. Theoretically, the Central Tenders Board is under the oversight of the cabinet. However, in order to ensure that there is no political direction or undue influence, it functions in practice independently. Indeed, under my instructions, not even the agenda and minutes of the board are to be circulated to me or any other cabinet member. Scrutiny of the board's operation is done through its interface with the permanent secretaries. The substantial tenders which go before the Tenders Board are in relation to projects for which funding is provided by institutions such as the Caribbean Development Bank, the World Bank, and the European Union. These multilateral agencies have their own tendering procedures, which must be applied by the Tenders Board, and their no objection has to be secured before the award of the tender is completed. The multilateral agencies fund in excess of 70% of the country's capital budget. Small contracts for goods and services below US $8,000 can be awarded outside of the Tenders Board procedure by the permanent secretary of the relevant ministry in accordance with financial regulations. The Director General of Finance and Planning, the Accountant General, and the Director of Audit are the external checks against the abuse of ministries of small contracts. Inquiry may be launched by the Executive or the Director of Audit in the event of a reasonable suspicion of abuse or misconduct in this regard. In the 13 years thus far of my administration, 2 such inquiries were launched, and independent of these inquiries, several prosecutions were initiated in the courts. At a much larger level, my government launched a judicial inquiry under the Commission of Inquiry Act into Eastern Caribbean 200 million shipyard and marina project at Otley Hall and an associate project at Union Island, which were implemented by the previous government in conjunction with an Italian investor. This inquiry is still ongoing and has been subjected to many legal challenges. My government has amended the law to better prosecute this inquiry. The absence of integrity legislation to ensure the declaration of assets and liabilities by parliamentarians and other high office holders, and the criminalizing of illicit enrichment is a gap which ought to be filled in the architecture of anti-corruption regime. However, the challenges to the effective implementation of such a law are substantial, given the fact that the salaries or stipends of chairpersons and members of the Board of Public Enterprises are so small. It is likely that the already narrow pool of qualified personnel from whom to draw would dwindle further with the declaration requisites of integrity legislation. The same apply to holders of political offices and permanent secretaries. Judges find a way to exclude themselves from the remit of integrity laws, as the case in Trinidad and Tobago indicates. In November 2009, my government placed a comprehensive constitutional reform before the people in a referendum. One reform was for the establishment constitutionally of an integrity commission. My government lost the referendum by a vote of 57% to 43%. 1 year later, my government was re-elected to office. The existing legal framework to fight corruption and money laundering offers a strong deterrent to corrupt conduct. Politically exposed persons find it very difficult to open a bank account or make a transfer of funds. The hurdles which politically exposed persons and their immediate families face in the banking system for even legitimate transactions are huge. These hurdles are scaled, however, with openness and transparency and source of funds and the nature of transaction. One of the major areas for genuine reform in an anti-corruption regime revolves around the financing of political parties. It is a difficult area, as can be seen from the experience of the United States of America. The easiest way, theoretically, is to ban all financial contributions to political parties and cause the state to finance political parties during and outside general elections. That, however, is unlikely in the Caribbean. This thorny problem of financing of political parties, however, demands a solution. In concluding, it is my view that the proper functioning of established law and order institutions, underpinned by a supportive political civic culture, is the way to fight corruption. Specifically targeted measures have the potential to yield additional anti-corruption results, but in the absence of settled good governance and a supportive culture, specifically targeted initiatives do not deliver optimal results and may even weaken the overall war against official corruption. This fight, of course, must begin from the top and the leadership. Thank you, ladies and gentlemen.
Thank you, Mr. Williams, for delivering a message on behalf of the Honorable Prime Minister. And of course, we would ask you to convey our thanks to him for taking time to prepare his speech and send it so we can have the benefit of it. Ladies and gentlemen, our next speaker is Ms. Cheryl Ann Lister, OBE. She is the chair of the National Anti-Money Laundering Committee of Bermuda. Ms. Lister is a government scholar. She received her BSc honors in probability and statistics, my God, from Queen's University, and an MBA in finance from the University of Toronto. She's a qualified chartered financial analyst and a very passionate advocate for integrity in public life. I had the pleasure of working with her when I was in 2011, 2012. I was chairman of the Caribbean Financial Action Task Force, and she was my right-hand person during all of that turbulent period, if I might put it that way. So please give Ms. Cheryl Ann Lister a warm Caribbean welcome. Thank you.
Good morning, Mr. Premier, Honorable Attorney General, Mr. Williams, other dignitaries, distinguished ladies and gentlemen. It is certainly a pleasure for me to have the opportunity as the representative of the Premier of Bermuda, the Honorable Craig Cannonier, JP MP, and the Bermuda government to share with you regarding Bermuda's work to address bribery and corruption and to provide information on the comprehensive regime that we have developed. However, let me first of all congratulate President Roy Budden and the University College of Cayman Islands team and all of those who have been involved in the organization of this very special conference for their work in bringing together so many key people to discuss such an important and timely subject for all jurisdictions, namely towards a corruption-free Caribbean, ethics, values, trust, and morality. Thanks also to the Governor and the government of the Cayman Islands for their courtesies and assistance which have been extended to us during this time. Bermuda has, over the years, taken steps in many areas to demonstrate its strong commitment to a high level of compliance with international standards and to play its role in the global fight against crime. As a result, Bermuda has developed a reputation for being a quality international financial center, primarily in the areas of insurance and reinsurance, and has a long history of knowing its client, with strong legislative provisions in key areas that have contributed to Bermuda's success in this regard. In relation to bribery and corruption, relevant legislative provisions were inserted into a number of different acts over the years, which it was hoped would act as a deterrent to such types of behavior. These acts include the Parliament Act of 1957, the Parliamentary Election Act of 1978, the Rehabilitation of Offenders 1977 Act, the Quarantine Act of 1946, and the Criminal Code of 1907. The various provisions were intended to impact the conduct of ministers of parliament, persons in the public sector, as well as the general public. In relation to members of parliament, offenses in this area include asking, receiving, obtaining, or even attempting or agreeing to receive or obtain a bribe or other such type of compensation. In addition, there were relevant offenses relating to the election process, which would also bring into scope persons who form part of the legislature. Further, a ministerial code of conduct was established in 2002, which was expected to govern the actions of members of cabinet and prevent corrupt activities. In regard to persons in the public sector, key provisions were inserted in the Criminal Code of 1907. This act also addresses offenses relating to judicial corruption. And there were also other legislative and legally binding restrictions which were intended to define the activities of employees in public service, as well as impose penalties for failure to comply. Corruption-related offenses that were created over the years that are applicable to any persons, regardless of their role or status, include offering and giving of a bribe to members of parliament or workers in the public sector, corruption or attempted corruption of jurors, the judiciary, witnesses, and other such persons, as well as a number of offenses falling under the head of corrupt practices detailed in the Criminal Code. As noted earlier, Bermuda has had a long history of knowing its client, with legislative provisions dating back to 1939, and I underscore that again, dating back to 1939, requiring persons to provide information relating to beneficial ownership. These provisions have been updated and enhanced over the time. Therefore, persons wishing to incorporate a company in Bermuda must submit relevant details on the ultimate beneficial owner, which is subject to vetting before a decision is made on the approval of the application. This has resulted generally in a culture of compliance. Our regime is supported by a comprehensive and effective regulatory regime for the supervision of financial institutions, which includes trust and corporate service providers, and a strong and robust framework to combat money laundering and terrorist financing, all of which have been updated and strengthened over the years. These various requirements that I previously outlined to you, along with other relevant provisions that are in place in Bermuda, have for many years provided the basis for the regime to combat bribery and corruption in Bermuda and to assist in the global fight in this regard. However, more recently, the Bermuda government has taken further steps to reinforce the legislative framework for corruption, particularly as it related to the public sector, as part of an enhanced commitment to fairness, openness, and transparency. As a result, there have been a number of developments, both legislative and operational, to ensure greater accountability in the public sector. The Office of the Ombudsman, which was established as an independent agency in 2005 to investigate complaints about any government department or public authority and to address issues related to maladministration. In 2010, the Office of Internal Audit was set up as an additional level of oversight, particularly in relation to financial operations and controls of a department, ministry, or quasi-governmental organization. Public access to information legislation was enacted by Parliament to enhance transparency, and it's currently steps are being taken to implement that legislation. Bermuda has also been heavily involved in the area of tax transparency, both in terms of the policy development and the practice development in their work with the OECD, and has signed a number of tax agreements, as well as been a signatory to the multi-agency tax agreement, multinational, tax agreement. Then in 2011, even greater emphasis was placed on addressing accountability and governance matters, including high standards of ethical behaviors, with the introduction and passage of the Good Governance Act of 2011. This act made a number of amendments to the Public Treasury Administration and Payments Act of 1969, the Audit Act of 1990, and the Internal Audit Act of 2010, while also providing protection for businesses in their dealing with government and for employees in their companies by embedding in the Employment Act provisions relating to whistleblowing. I will move forward a bit quickly because I'm cognizant of the time, but a copy of the speech will obviously be available on the website. But I would note in particular that the Good Governance Act of 2011, in relation to procurement matters, because that was a key focus of that act, achieved its objectives through the establishment of an Office of Project Management and Procurement as the authority to have oversight of all procurement functions in government. It also established regulations to define a code of practice for procurement, established penalties for noncompliance, and embedded in the framework provisions to satisfy key principles relating to transparency, consistency, objectivity, and promoting equal treatment to all participants in the tendering process. When this act was brought into force, particularly, as I said, with its focus on the procurement process, the result was greater rigor in many key practices and procedures undertaken by public sector employees, accompanied by the strong penalties to encourage compliance. As the then Premier said in the brief introducing the bill, and I quote, "We wish to communicate a strong and clear message to the public that government has zero tolerance for behavior and practices that do not accord with the highest standards of good governance." Then in 2012, the project to enhance the standards and culture of governance resulted in yet another good governance bill being brought to Parliament, namely the Good Governance Act of 2012. This bill established a procedure for a minister to consider an application or appeal on behalf of another minister in certain circumstances. It also created criminal offenses of terminating a contract with or withholding a payment from certain whistleblowers, and created criminal offenses in relation to collusion in the awarding of government contracts. Further, it increased the time limit in the Public Treasury Administration and Payments Act of 1969, the Audit Act, and the Internal Act to provide that in prosecution for an offense under either of these acts, that they could be brought within 3 years, which was an override of the Section 452 of the Criminal Code, where the time limit for certain proceedings was only within 6 months and no more than a maximum of 12 months. All of these new provisions were put into place to help strengthen accountability and integrity and increase transparency and oversight in government operations. Further, the inclusion of integrity provisions in all government contracts, namely anti-collusion provisions, only serve to strengthen the framework to combat corruption in our country. Although the actions mentioned thus far in this presentation are significant in addressing the risks and vulnerabilities relating to bribery and corruption, Bermuda is not resting on its laurels in this regard. Currently, work is ongoing to review and update the Ministerial Code of Conduct, the Financial Instructions, the Civil Service Code of Conduct, and the Procurement Code of Practice to ensure that good governance is applied consistently in all of the documents that govern conduct in the public service. A joint team consisting of staff from the Cabinet Office and the Office of the National Anti-Money Laundering Committee is currently reviewing the provisions of the United Nations Convention Against Corruption and the OECD Anti-Bribery Convention to determine what additional gaps still exist in Bermuda's extensive arsenal to fight corruption and bribery. Once the existing gaps in relation to these national conventions have been addressed, then application will be made to the UK government to have these conventions extended to us. Notwithstanding the comprehensive regime that we have in place to prevent and deter corrupt activities, there have been instances where persons have acted outside of the relevant laws. As a result, action has been taken, which has included public prosecution of individuals. We recognize that it is not enough just to have laws in place that require ethical behavior, but there must also be enforcement action taken to penalize noncompliance. This can only serve to reinforce the effectiveness of the regime and create a culture of compliance and integrity. In closing, I would state that, as noted at the outset of this presentation, Bermuda's commitment to a high level of compliance with international standards is strong. We have spent decades building our positive reputation and becoming a respected participant in the international financial community. I have highlighted in this presentation the significant work that has already been done to enhance and update our governance structure and to build a strong and robust regime to combat bribery and corruption, and also to enforce high standards of integrity and ethics. However, we do recognize that corruption impacts all sectors of society, and participation at all levels is required to effectively prevent and to fight this scourge. We will therefore continue to promote integrity and accountability in the management of public affairs and public property, and also to promote good and credible private sector governance. We pledge to work with all of the members of the Caribbean family as we move toward building a corruption-free Caribbean based on strong ethics, good values, well-founded trust, and a commitment to morality. Thank you very much.
Thank you, Ms. Lister. I'm sorry we have to be rushing you through your speech, but it's very detailed, very helpful, and we thank you for sharing the Bermudan perspective with us. And we would also like you to convey our thanks to the Honorable Premier for allowing Bermuda to participate in this important and august forum. Ladies and gentlemen, we do have some time constraints. I gather the Honorable Prime Minister from the Bahamas, who's next, is in the House. So we're going to give him an opportunity to catch his breath. And in the meanwhile, we will field about 3 or 4 questions to our panelists. If you could keep it brief, please, we would certainly appreciate that. Thank you. Easy questions. Is there a mic? Professor Monroe, is there a mic?
First of all, I'd like to congratulate all the presenters and to appreciate the progress being made as reported. 3 quick questions. 1, could I hear more about the prosecutions in relation to Bermuda? We're told that public prosecutions of individuals has taken place. What's the level of those prosecutions? Low level, medium level, high level officials, the prosecutions in Bermuda. Secondly, in relation to St. Vincent, the Honorable Prime Minister made the declaration that financing of parties is a difficult in relation to the financing of political parties in St. Vincent. Difficult issue, but what are the solutions being considered? It cannot be left simply to say that it demands a solution. What are the solutions that are being considered? And again, in relation to St. Vincent, what is the difficulty of criminalizing illicit enrichment as recommended by the United Nations Convention Against Corruption? What is the difficulty there? And finally, Attorney General Bolgen, you answered in part the criticism, the concern that has been expressed in a number of international documents about the low number of prosecutions for money laundering in the jurisdiction in which we are, in the Cayman Islands. Does this mean that we're not likely to have any?
Thank you. With regard to prosecutions, I'll put them into 2 categories. One would be money laundering prosecutions, where since 2008 there has been a lot of focus of ensuring that we have been investigating and prosecuting or bringing charges for money laundering itself as a way of trying to weed out the unacceptable behavior. And we have had since 2008 more than 15 successful prosecutions for money laundering itself. We've also had a number of situations where there have been civil asset confiscations and forfeitures and other such type of action taken to deprive people of the proceeds of their crime. So it's been an area where we've had real focus, and we have reaped the benefits as a result as a nation as a country, sorry, not a nation, as a country in terms of making sure that we make send a very clear message that this behavior is not acceptable and will be addressed. With regard to corruption more specifically, or things that relate, and I'll refer to sort of public sector officials, there have been a number of sort of high-profile cases recently with fraud and money laundering charges also have been brought, and there have been jail sentences as successful convictions and jail sentences which have resulted from them. And I think, if I'm correct, there have been 3 of them that have been quite high profile, very, very extensive, very long cases, but certainly the police and the prosecutions have demonstrated that they have the stamina and are willing to do what is necessary to get the success, make sure that the convictions are successful. So I would say that it is something that we are focusing on, and that we are getting the support of the community, of the law enforcement, and of the community more generally, to say that because we are getting success, the convictions are being successful. So people are saying, no, we don't want this in our community, and we're prepared to stand up and say it's not acceptable. And the judiciary as well has supported it by imposing jail sentences in many cases where it was deemed appropriate. So we're thankful for that.
Thank you very much for your question. As it relates to the issue of financing of political parties and the solutions being considered, of course, much debate and discussion has been undertaken as it relates to this issue. The first solution that comes to mind is the one proposed but also the one rejected, in that the country, the government, can offer to fund the political campaigns. However, this is very challenging given the limited resources of the jurisdiction. I know what is being done is that where policies have been implemented in other jurisdictions, for example, the declaration by donors, this is something that is being currently studied, because one size does not necessarily fit all. So we have to look at finding what is the most feasible solution in our jurisdiction. So that debate is going to continue, and we are going to look at the best practices in various jurisdictions. As it relates to the enrichment, illicit enrichment, I believe this is also part of the ongoing dialogue, and we are cognizant of the fact that there needs to be some legislative reform undertaken to reflect provisions addressing this particular issue.
Thank you. To Professor Trevor Monroe's point about whether we would have any criminal prosecution for money laundering, the short answer is yes, we will. We continue to have numerous prosecutions for money laundering. I think where we have failed is not publicizing the statistics and so. So for your part, considering the work you do, we undertake to send you a spreadsheet with the numerous prosecutions of money laundering over the last, say, 4 years, so that we can update our record. But it is a continuing process for us. We have prosecuted numerous people at all levels, and we will let you have the benefit of those stats. Thank you. Another question? One more? Sorry.
Hello, I'm Andrea Brown Phillips, Center for Values-Driven Leadership at Benedictine University and with the Madison Strategy Group. And my question is for anyone on the distinguished panel. We're here examining the confluence between business practices and values, ethics, morality, and it's really easy for those things to roll off of your tongue. But the first question you want to ask is whose values? And whereas we're seeing a lot of regulation, legislation, public policy, and practices that are more towards the responsive or reactionary side of things, I'm curious to hear more about what we're doing proactively on the preventative side of things when we talk about opportunities for leadership development or emerging leaders or middle-level and senior-level managers. Where are they getting exposure to seminal readings, experiences, case studies, and other learnings that may empower them and also, I think, give them the confidence to take that courageous step and build their resilience in their fields? Thank you.
Whose values? Yeah, with the regulations and so reflect.
Yes, it's our society, isn't it?
I'm not sure I got the last part of the question, but I believe the issue essentially is whose values should the laws and regulations reflect? Well, first and foremost, you look at the specific society in which you operate, because sometimes the laws and regulations, they have to take into consideration the country's circumstances. But more importantly, I believe internationally there are a set of best practices. And when we look at putting in place regulations, rules, guidance for our entities, we want to ensure that they meet the international standard. So I believe that is the process by which we should be guided. What is good overall for your country? Yes, but what is the best practice internationally?
Any further questions? Yes, I think we need to pose one question to the Premier. I don't think you should get up so lightly.
Well, if I can just comment very briefly on that question, which I had some difficulty hearing. I think instinctively, intuitively, we all know, regardless of where we come from, what's right and what's wrong. And dealing with issues about corruption, that is essentially the question you have to ask when you are formulating the policies, when you are trying to develop the legislation. If what is being done requires abuse of office, requires a favor, requires something to be done with respect to a particular individual or entity, which is not going to be done or made available to everyone generally, then it must be wrong in principle. I don't think we need to try to delve into what are the value systems of one country as opposed to the value systems of another. I believe that as humankind, we all know instinctively what's right and what's wrong.
We should not need to legislate values.
The AG is saying to me we shouldn't need to legislate values.
Well, thank you, ladies and gentlemen. I think we managed to pull back some of the time, and it has been quite insightful. I would like you to... Sorry.
Sorry, we can't hear you.
My name is T. Ray Campbell. I'm assistant professor from Livingstone College in Salisbury, North Carolina. I just want to follow up on a question the Premier answered now. How do you legislate values? How do you do that?
You said you can't.
I said we can't legislate values.
Thank you. I hope we've clarified. The point is that you don't have to, or we shouldn't have to. And you can't legislate values and attitudes. You can't legislate integrity in public life. It's a cultural thing. You need to have the right person, the right place, who understand what these values are and are willing to impart them. And so, thank you. Can you join me in thanking and providing applause for our panelists? Thank you very much.